Hello, everyone. Welcome to another episode of LegallyWired. On this episode, we'll look at a simple technique that will help us unpack and learn any new law that we're looking at for the first time. So, this technique's quite simple and it's always been around. Whenever a legislature passes or enacts a law, the purpose is to fix an underlying social issue or fix a loophole that the market is trying to exploit. So, if you understand the social issue or the loophole, you will automatically understand the law better, including any of the nuances that the law is trying to cover. As an example, let's look at Section 188 of the Companies Act 2013 that deals with related party transactions. So, before we go on to reviewing Section 188, we need to get background and context of Section 188. Now, here is where AI comes to help. Instead of going on a Google, looking and reading multiple articles to build that background prior to reading 188, the most easiest route would be to use any AI platform and get a limited background understanding. We don't need a very detailed background. I know a lot of you might be thinking that AI might not give the exact facts and something might be missing. So, is this the right way to do it? But the point is, for background, we need a broad stroke understanding. We don't need to know all of the facts. We just need to generally understand the problem that existed, and we need to be able to visualize and think about how the law would have fixed this problem. The whole purpose of this method is to be able to actively read Section 188. So when you do it this way, you know what to look out for in Section 188, and you're going to be actively reading the law. So I'm going to copy this. By the way, you can use this prompt on any AI platform. You can use it on GPT, you can use it on Gemini, you can use it on Perplexity, any platform that you deem fit. So I'll leave this prompt in the comments below. You can use it for other laws also. You just have to change the provision of law over here. And then you can run it for other laws also. I've done this in the past and it's a really helpful trick that I use. So anyway, we've generated the content now, and if you look through it, it says Indian companies, especially promoter controlled ones, were quietly moving cash, contracts or assets to owners, relatives or group entities through related party transactions approved by friendly boards. Because outsiders had no real veto and disclosures arrived late, self-dealing drained value and minority shareholders bore the loss. So I've gotten the context by just reading this paragraph. I'm not sure how many others have gotten the context. So it's quite simple. Essentially, a lot of promoter-driven businesses, they do self-dealing by entering into deals with other entities which are either owned directly or indirectly by them. So the problem with this kind of self-dealing is that, like the text said, they'd get an approval easily through the board and then they'd siphon off the company's funds or funnel it into an other entity, which would represent a loss to other shareholders who've contributed capital to the business, especially investors. Investors, when they invest in a company, generally they are the ones who bringing most of the cash, but they are a minority shareholder. And if it's a heavily promoter influenced company, they can use the related party route to siphon off the investor funds and funnel it into other entities. So there must be a process to do a check on these kind of transactions. The law is not saying that all related party transactions are bad, but if it is a transaction that's not in the ordinary course, and it is not on an arm's length basis, then there must be notice to the shareholder that the company is about to conduct such transaction, and details of those transactions must be disclosed, and the shareholder must approve such transactions, because ultimately minority shareholders also put in capital into the business. Um, so that is an issue, and if the law doesn't control this, the larger issue is investors will lose confidence in investing in India, because they're not sure if the funds are being used to build the business and therefore build more value. So it has to be definitively addressed. Now, the second paragraph is talking about the trigger event that led to these RPT related laws, and they're referring to the Satyam Maytas scandal. So I'm not going to go into depth into the Satyam Maytas scandal, but it is a definite case in point as to why we need robust related party transaction rules. So in this particular case, the Ramalingarazu family, they created invoices for up to 7,000 crores to as if, and this is all fictitious money, it's not real money coming into the company. And the reason why they created these fake invoices to show 7,000 crores in their books is to build the value of the business and increase increase share price on the markets where they were listed. So now, to cover up this whole of 7,000 crores, they wanted to enter into a transaction to purchase two entities which were again owned and controlled by Mr. Ramalingaraju's sons. So essentially this is a related party transaction. The entities are Maytas Properties and Maytas Infrastructure. Maytas is essentially Satyam spelled backwards. So the deal was passed through at the board level. It didn't go through because there was heavy investor backlash. I mean, the transactions didn't reflect any rationale. I mean, the assets that they were purchasing had no bearing on the business of the company, and it was a way to funnel out money from the company. The deal was valued at $1.6 billion, which is the roughly equivalent of little more than 7,000 crores, I would say. But the whole point was, I mean, we don't know if they intended to again funnel out $1.6 billion, or we don't know if this is just to be squared off. I mean, not sure how they would have even pulled it off. But anyway, it didn't get to that point, and Ramalingarazu had to cancel the transaction, and he also confessed to the fraud, and then ultimately law took its own course. But this whole episode showed why we needed robust related party transactions. Related party transactions was already regulated by the 1956 Act, but clearly there were a lot more loopholes, and they needed to build on that to have a more robust mechanism. So now, basis this understanding, I already know I have made a mental note of what on my notepad on what I'm supposed to look out when I read section 188. Firstly, I'm looking to see if the law identifies what a related party transaction is, right? And if there is a mechanism for shareholder approval, and finally, is there who is a related party in reference to a company? So with these questions, I'm going to look at 188. Now, because I have these questions, I'm going to actively read 188 when I look at it. So look at the first sentence. Except with the consent of the board of directors given by the resolution at a meeting of the boards and subject to such conditions as may be prescribed, no company shall enter into any contract or arrangement with a related party with respect to, and it has a listing of all the transactions. So limbs A to G, I list out all of the related party transactions, and it also automatically shows us one guardrail, that is you need the consent of the board of directors. And the consent should be procured in a certain manner. If you click here, it goes to the rules and the rules will tell you how the board meeting should be conducted. We're not going to go into that. This is just a demo to help you understand 188 better. So if you read, I'm not going to read the limbs of A to G verbatim, but if you read 188 A to G, you will note that the net effect of all of these limbs is the funneling out of the monies of the company, or either resources of the company, intellectual property, or other services that the company can provide, probably at a lower rate, thus enhancing the value of another related entity. So resources or either cash is being funneled out, and that's the net effect of all of these related party transactions. So if you look at the next part, provided that no contract or arrangement, and no contract or arrangement referring to contract or arrangement in relation to the related party transaction described, any of the related party transactions described between limbs A to G. In case of a company having paid up share capital of not less than such amount, or transaction not exceeding such sums as may be prescribed, shall be entered into except with the prior approval of the company by a resolution. So prior approval of the company by a resolution always means shareholder resolution, which means that shareholders must be notified in certain circumstances on related party transactions. Now the circumstances are again contained in the rules. If you click this link, it will take you to the rules. I'm going directly to the law because I do know rule 15.3 over here. And essentially, if you go through 15.3, it's just saying that it's giving you a number threshold. So it's saying that for transactions involving sale, purchase, or supply of any goods or material which are 10% more than the turnover of the company, you need a shareholder approval. Similarly, selling or disposing any assets of the company which is and value of the transaction is 10% more than the net worth of the company, again you need shareholder approval. And leasing of property of any kind amounting to 10% or more of the turnover of the company, again you need a shareholder's approval. Just imagine, right, like if a company has a turnover of 100 and you want to get a lease of 20 or 30 rupees, that is 30% of the company's turnover. Now this 100, the 100, which is the overall capital or paid up capital of the company, is contributed by a number of shareholders, right? So they need to know how their funds are being utilized. They need to be able to approve such a transaction, specifically when it is with a related party entity. So 10% is generally the threshold. Anything above 10% of turnover in most cases, and in the case of acquiring an asset, if it's 10% more than the net worth has a different definition under Companies Act. So if it's more than that, then you need to go to shareholders, because that's a big piece of the total capital that will be funneled out of the company, and that requires a shareholder approval. So you see how easier it is to get these concepts once you have background understanding of why the law came into place in the first place. So the next one, provided further that no member of the company shall vote on such resolution to approve any contract or arrangement which may be entered into by the company if such member is a related party. So member is a shareholder, and if a shareholder is a related party, then they shouldn't be they shouldn't be able to vote on such resolutions, which is only fair, right? Because they will vote in their own self-interest. That's one vote that goes in self-interest. So that has to be excluded from the purview of counting votes. So there's also a link to the definition of related parties, what I assume. So the definition of related parties provided under section 2 doesn't show up. We can look into that after we see 188. Provided that nothing in this subsection shall apply to any transaction entered into by the company in its ordinary course of business other than transactions which are not on an arm's length basis. So arm's length basis is again defined. Arm's length transaction means a transaction between two related parties that is conducted as if they were unrelated, so that there is no conflict of interest. So essentially 188, the guardrails of 188, which is getting the approval of the board and the shareholders, is not necessary if a transaction between two related parties was done on an arm's length basis. Now, arm's length is as if the transaction was conducted between two unrelated parties. It's very difficult to prove what is arm's length and what is not arm's length, but then this is the law. So you kind of see how the law is not against all related party transactions, provided that they've been done on a competitive basis. There's also another proviso I wanted to show, and it makes sense because you know the context, which we skipped. So provided also that nothing contained in the second proviso shall apply to a company in which 90% or more members in number or relatives of the promoter or are related parties. So in a case where it's a family run business, 90% of the shareholders are all related to each other, they're all related parties to each other in reference to each other, then really the law doesn't care so much, because 90% of the capital of company is pulled in by these substantial, you can't say 90% of the capital, but because there could be a scenario where the 10% of the members who put in the capital, the actual monies that they put into the business is more than what the family has put in. That can be a scenario. So I'm not sure why the law is designed in this way. And this can be a commentary piece that a lot of you can pick and choose to write about, of how this kind of creates for heavy family driven companies, it is a red flag to consider. So now we can go and look at the definition of a related party. Like I said, it was defined in section 2. Yeah, so in reference to a company, it defines who a related party is. So a director or his relative, a key managerial personnel or his relative. You will notice that any person who's designated as a related party will also include his or her relative, right? A firm in which a director, manager or his relative is a partner. A private company in which a director or manager or his relative is a member or director. A public company in which a director or manager is a director and holds, along with his relatives, more than 2% of its paid up share capital. Any body corporate whose board of directors, managing director or manager is accustomed to act in accordance with the advice, directions or instructions of a director manager. So they've also identified other entities where it's not just direct control, but there is also indirect control. That is a scenario where the directors, the managing directors, just used to acting on the instructions of the director manager of the referenced company. Any person on whose advice, directions or instructions a director or manager is accustomed to act. So you notice how the definition of related party is wide, and any of these persons who fall under the definition of a related party, and if they conduct any related party transaction, which we saw between limbs A to G of section 188, and the net effect of all those limbs is funneling out of money or resources, would be a related party transaction. And those transactions, they generally require the approval of the board in a certain prescribed form. I didn't go through the prescribed form because that's largely procedural, and it talks about how the notice have to be given to the members of the board, and that the notice should set out the agenda plus also the interest that the directors have in that particular related party transaction. All of that has to be disclosed, so it's on record. And in certain scenarios where there's that 10% threshold, where if it's greater than 10%, then you again need shareholders' approval. This is how you can learn the law better, when you get a background or context of the law. We can do more of these videos and look at other laws that you are interested in. Please give your comments below, and we will do similar videos to understand those laws. I hope this was an informative session for you guys, and I look forward to your comments and feedback. Thank you.